All right, welcome back to another special episode of The Unknown. My name is Michael Volpe. I write at michaelvolpe.substack.com. I live in Chicago, Illinois. That's in Cook County. And my broadcast partner, Richard Luthman, writes at luthman.substack.com. That's with two N's, Luthmann. And he's in Florida. Pretty sure it's Lee County, Florida. I'm not sure which city it is. I do know that Lee County, Florida, for some reason was named after a loser, Robert E. Lee. We just passed the anniversary of the Appomattox Courthouse, where he had to surrender to the very generous terms of Ulysses S. Grant. So today we're going to be talking about a bill that both of us thought probably wouldn't be law yet because the governor probably wouldn't sign it quite yet, but it is HB 668. It was supposed to be, I thought it was a landmark custodial interference law or bill that could have turned into law. And it passed out of and it's in Idaho, we should say, in Idaho. And it passed out of the Idaho House 68-1. And then it ran into serious interference, not even in the Senate, the state Senate, but in the state Senate's Judiciary Committee, where it lost 5-3. That means the Judiciary Committee of 8 people, there were 4 more no votes in that small committee than there were in the entire Idaho House. But the reason that it got voted down, I think, is very interesting. So what I did was I created a mashup, if you will, of some of the most important parts. So we're going to start first. You're going to hear State Representative Heather Scott, who is the sponsor of the bill, talk a little bit about the bill. We'll listen to her, and then we'll talk about what she was referring to.
We stopped at 7 different locations across the state, and one of the biggest was child custody interference. We heard multiple times from law enforcement and public servants and others that the system had failed them, that the legislators had failed them to give them guidance into a process. And so that is what this legislation attempts to do. The bill sets up some clear penalties for custody interference and the process, and I'd like to just go to the bill and go through it really quick with you. I will say what custody interference is when parent A is supposed to drop off the child to parent B, and for some reason they just don't show, or they just ignore their custody order and don't show up. And so parent B really, with the current law we had that was having a lot of issues, how do you address this? What happens? And they can call the cops. We've discussed a lot with the cops. They come out to these cases all the time, and they basically just say, you're going to have to go back to the courts. We can't do anything. So that's
a couple for myself.
Hold on. We're going to listen to that. So that's her laying it out. And right here is the current law. And what the current law said, it describes custodial interference and it describes the penalties. But as she said, there was no guidance from the legislature about what to do when you have custodial interference. So they produced HB 668. It's more than what you're looking at on the screen. However, what you're looking at on the screen is the most important part, and that says, for any report of child custody interference, law enforcement officers shall, number 1, verify the location of the minor, and if possible, do a welfare check safety and well-being of the minor, and 3, complete a written offense report based on the law enforcement officer's findings, and then they describe what the report should have and the details of the report. And so you and I thought that was great. And we thought it was great because of something that we heard. And so this is from the very first Idaho Child Custody and Domestic Relations Task Force hearing. And I'm going to mispronounce the guy's last name, but this is the chief of police of Meridian, Idaho, which is right next door to Boise. want to describe, he was asked a hypothetical about if a parent is taking a child and what the police can do.
For a week or maybe even a month or whatever it is, and then when it's time to return the child, they either don't show up or they refuse to return that child. And so we really don't have any ability to make them give that child back because it is a civil matter. And when we reach out to our prosecutors and the attorneys, we're all usually given the same advice, right? Unless we can prove that there is a safety issue there, then they need to work it out through their attorneys.
All right. So I want to describe, he was asked he basically says cops can't do anything about custodial interference, and that's why they wrote the law the way they did.
Yeah.
You want to add anything?
We spoke to State Senator Tammy Nichols, and I thought, we know from Senator Heather Scott's statements that they agree that there was a void in the law, and the question becomes: do we leave this to the discretion of police officers, or do we put out a very basic list of things, of facts that we would want to put in front of the family court judge for further, analysis or further, or further legal process?
Mm-hmm.
And the fact is that when you leave things to the discretion of police officers, and I love police officers, a lot of them are great, but at the end of the day, they act defensively. The police officer, walk into, the house and they'll see the empty safe and say, Mr. Officer, we were robbed. And they don't want to do the paperwork. So the first thing they'll say is, are you sure that you were robbed? Or are you sure that it was just an unattended larceny? You were looking the wrong way and the door was open and somebody came in your front door and stole the jewels out of the safe. You get some cops that are like that practice policing, overly defensively, like they don't want to do anything. Like they don't want to shoot the guy because they don't want to fill out the paperwork. The guy's about to draw on them.
That's why this word shall is very important because it requires, because this guy's saying that there's nothing we can do, and we've talked to lawyers and our hands are tied. So as a result, the legislature is trying to untie their hands, right? So now we are directing the police. Now, I want to point out, it is a crime, custodial interference. A violation of this provision of subsection 1 shall be a felony unless the defendant did not take the child outside the state and the child was voluntarily returned unharmed prior to the defendant's arrest, in which case the violation should be reduced to a misdemeanor. Felony, misdemeanor, these are criminal codes. It's a crime. Now, any other crime, doesn't the police investigate?
Well, yes, and that's part of what the police do. They investigate crimes. And you know what? In the criminal area,
hold that thought. So next we're going to hear from several, but we're going to hear from one of the several state senators who didn't like this bill, and they're going to tell you why they don't like the bill.
I also really appreciate the effort. In my former life, as a prosecutor, I did family law for about 6 months, knowing after that that's not the area of practice that I want to pursue. It's a very frustrating situation for those involved, but it's also one it's essentially a civil situation, and you've got the judge that's overseeing it. People may get frustrated with him, but they understand the nuances of their orders and who may be appropriate for custody when. And I share Senator Foreman's concern about inserting a police officer in this situation when really it's the family court that knows the circumstances the best and has all the documents. And so I guess I'll just make that comment, and then I've got some other questions. Any other response in regard to that?
Sure, I would love to. So this is child custody interference is already in criminal code. It's already there. So what we were told over and over in these hearings is the legislature has not provided guidance. That's what we're trying to do, is some guidance, some.
All right. So he called it a civil matter. The cop called it a civil matter, even though it's
Yeah.
a criminal code. The second thing is, do we really want the cops? And we're going to hear, I did it out of time order, Foreman. And by the way, the person speaking was this guy right here, Todd Lakey. He's the head of the Judiciary Committee. He's one of 5 people who voted against it. There's another one we'll go through. Here are the 5. James Ruckty voted against it. Senator Dan Foreman, we'll hear from him later, and David Lent. He is calling it a civil matter, even though it's a crime, and he doesn't think that the police are appropriate. He wants a family court judge to do it, except the family court judge is not capable of issuing a criminal order, because they can say contempt. They can say that you engaged in custodial interference, that is contempt of court. But as I said, it's a criminal statute. And for some reason, this one criminal statute in particular, these legislators don't think the cops should investigate. What do you think of that?
Well, this guy, I think, there's a very specific term of art for it. I think he has it ass backwards. I think anybody that understands family court, that's been in family court, that has survived family court, understands his idea about it being a civil matter shows that he's naive. And he even admitted that family court's not the place for him. And it's a good thing, because when you go into family court, it's worse than criminal court. At least in a criminal court, you have a Bill of Rights, right? In a family court, the amount of power that the judge has over you to imprison you, to lock you in chains under the guise of equity. Okay, that's number one. Number two, the point that Heather Scott made is entirely correct. This is on the books as a law, a criminal law in the state of Idaho. Now, if we're going to take what that state senator says, then you can kidnap your kids. Go kidnap those kids in Idaho, because what he's saying is it's just a civil matter. You just have to pay a fine. Maybe you have to go see a judge. That's not how family court works. If you kidnap your kids, you're going to face a criminal charge. And when you get to family court, you may get additional contempt in the family court, as well as all sorts of other things. You may never see your kids again. This guy is living in fantasy world. It's not, sure as hell not Idaho or anywhere else than I know.
All right. And let's keep listening. This exchange is interesting.
Structure, some processes. Is this perfect? I don't know. Maybe the law enforcement will come back next year and say, hey, we don't want this part, or this is too much to ask. But we as legislators, I think, and for the problems going on across the state, I think this will keep more of these cases out of the courts, give a little relief to our judges who seem to be inundated with these cases. And I think there's enough discretion in there, like lines 22 to 28. If the law enforcement officer thinks it's reasonable. I mean, if neither of them have a custody order, usually they're meeting. You know what I'm saying? Or if neither of them have an order, it's probably not reasonable to give somebody a citation. It's going to ultimately go back. But he could report and say, hey, I showed up, the parent A is claiming this, and even if they write it up, and that's what we're trying to get some documentation, that parent can take that back to the court and just say, here's what, here's proof, because they don't have proof when they go back to the courts that parent A is violating these judicial orders. So does that answer your question?
I appreciate the response. So one of the things that when I was a prosecutor, we had traffic court day, which essentially is dealing with citations. You have a big stack of files and you go in there and you work on those cases. We're creating infractions here. The previous custodial interference was really for the serious cases that were felonies. Otherwise, they left it to the court. This feels like, to me, that you're going to create a family law day, essentially, with citations in court. And prosecutors and law enforcement having to come more often, not less often. Just interested in your response in that regard.
Okay, so I would respond that children are being denied access to their parents despite a valid court order. So I think that is serious. When a judge says, you get Johnny on Friday, Saturday.
So a couple things. I mean, one, he's basically saying if you force the cops to investigate these, then we're going to have so many that it's just going to be all of these infractions. That's number one. Number two, he doesn't think it's that big a deal.
He compared family court to traffic court.
Right.
You tell that to somebody that's fighting for their kids. You know what?
Right,
a car's
but
a fucking car. This is your kid.
This
guy's a disgrace. He's a disgrace. That's what he is. I don't know if he just doesn't.
He doesn't think, and it's not just a felony; it's a misdemeanor. And they changed the penalties from the current law, but the current law, I don't. The difference between the current law is not the definition of custodial interference. It's not that you could be punished for custodial interference. The difference is it requires the police to investigate. And this guy is saying, well, then the courts will just be so inundated. And that's a bad thing. And well,
and we get rid of traffic court day too, then, but while this guy's logic. Having that piece of paper that does what that proposed legislation says. Give us these facts. Give us facts to give to the judge, as Heather Scott said. That's a net positive. There are orders that are being ignored. There are orders that are being violated knowingly, and there are children that are being hurt. I can't think of better policy reasons. Ignoring a judge's order and hurting children. I can't think of anything better. This guy's worried about traffic court? Get out of here. Come on.
Number one, he's basically saying the custodial interference happens all the time and we're just letting it go. Number two, so what? Big deal. All right, let's keep listening.
Saturday and Sunday of every week, and that parent's denied parental rights because a person doesn't want to follow the court order. I think that is serious when these kids are denied seeing their parent or whatever parent. Law enforcement has said they lack clear direction. And I think the courts are burdened with all kinds of these motions. So you got to go back to court and file. I don't see a family day. I just see a lot of this going to get worked out before you go to court because you're going to have proof. So
members of the committee, I am Chief Tracy Bastrachea. I'm here representing the Idaho Chiefs of
Before we listen, that's the same guy. All right? Same guy. Okay. Now, I want to add, he's the chief of Meridian Police. However, as he says, he's not representing himself here. He's representing all police chiefs. So they basically, I presume because he testified at the other one, they said, why don't you go testify? Because I asked Meridian about that, and we're going to get to the statement, but let's listen to what he says.
Police Association. I can tell you that I did come to a task force meeting and speak on some of the frustration that we deal with right now with child custody. However, when we look at this bill, while we agree the intent is good, our patrol officers are not family court judges. They do not have the jurisdiction, the specialized training, or access to complete records needed, or the complete records needed to resolve complex custody disputes in the field. This bill shifts the burden of evaluating statutory affirmative defenses onto responding officers. In practice, this means an officer arriving on scene, often with limited information, under stressful conditions, must decide whether to reasonably accept a parent's explanation, and that is not a simple judgment call. It is a legal determination made without full evidence, without context, and without due process. This effectively turns a patrol officer into a roadside decision maker in what are often highly nuanced and emotionally charged family matters. Custody orders can be complex. They may be modified, partially sealed, or difficult to interpret, even to experienced judges and family court attorneys. Expecting an officer to interpret those documents on a sidewalk and make a real-time determination about the reasonableness of a parent's actions places them in an untenable position. The likely result of this is going to be inconsistency in enforcement, increased exposure to liability, and officers being second-guessed in court for decisions made under conditions they were never equipped to handle. They may be cross-examined not on clear enforcement actions, but on improvised legal judgments that should never have been their responsibility. Respectfully, this bill imposes a duty on law enforcement that belongs in the courtroom, not in the field. I would say, yes, we testified in the task force, but we were never asked to sit down and provide any input on any of this bill. The other thing I would say is this. I am not threatening a child with citing their parent, and I'm not citing for somebody else's.
All right, now what he's referring to is, and I don't know why Heather Scott said that, but she said a cop could threaten the child by saying, I can cite your parent if you don't come with me if the child is not coming, which she shouldn't have said, which should never happen. But as far as his complaints about the bill, number one, if the complaint is you're going to make a decision on the spot, then then amend and say you have up to 72 hours to write a report or however many hours. She doesn't have to make the decision in the field. Number two, they deal with domestic disputes all the time, this complex. They're the ones deciding if someone has violated a protective order. That's a crime. But suddenly deciding if somebody's violated a custody order, that's something a cop can't do. So I asked Meridian Police because I thought, man, at the other task force hearing, he's like, our hands are tied. We can't do anything. They want to untie your hands. I don't want that either. And I asked Meridian about that. And here is the response. Chief, I'm not going to pronounce his name right, so I'm sorry. He was testifying on, because I asked him, why does he keep testifying in against it? He was testifying on behalf of the Idaho Chief of Police Association. He is firmly in support of enforcing child custody interference laws. Is he? However, the law presented was done without input from prosecutors and or law enforcement. When asked for help on the bill so that it would be workable, law enforcement organizations were ignored. Passing bad or unusable laws just to make ourselves feel good is not good policy. If we're going to strengthen the child custody interference laws, they need to be sound policy and enforceable, not a law that is easily manipulated and skirted by either parent.
Okay.
Now, I did a follow-up, and I asked him, well, what is this?
What he said? You want to translate what he said? That statement from what he's just said at the hearing. Mm-hmm. At the hearing, he said, my officers aren't equipped to do complex tasks.
Right.
And in the statement that he gave you, the very clean statement that he gave you, he said nothing about the ability of officers to be able to do complex tasks. Mm-hmm. Now, when I asked you, Michael, that the statute itself, is that a complex task to do who, what, when, where, and why? There's nothing about complex tasks, right?
Right. Well, look, domestic disputes are complex. Assault can be complex. If one person says he hit me and the other person said, no, I only hit him because they were coming at me with a knife.
Michael, a fender bender could be complex because you could a good cop could notice, oh shit, the engine is leaking. Oh my God, we got to get out of here. Anything that a police officer responds to has the ability to be complex. Even a family dispute, but the run-of-the-mill one that this law was aimed to target was a collection of facts. Me and you agreed about that this was a great thing because it would allow for officers to collect a set of facts on a given day about a certain set of people related to a family court case.
Right. But again, they keep saying that cops are not the best ones to do this, that it's a family court judge who has no power to issue a criminal citation. It's just remarkable, but this guy bothers me because the current law, my hands are tied, so they come out and they untie your hands. No, you shouldn't untie my hands. We just don't
Yes,
want to investigate, period. Well, which one is it?
exactly.
Oh,
And like you said,
The
these
actions,
cops make
that
it.
truly is an
listen,
unconstitutional
now
action on our part.
after he's done, we're
Thank
going
you,
to hear
Chief.
certainly
from.
understand where you're coming from with the bill. I love the intent behind it. But in a different life, having been there many, many, many times, I'll give you my concerns, and if you could take a minute to just address those. Again, I like the intent. I think as written, we may be putting too much burden on law enforcement in the field. Law enforcement rarely has the paperwork or the insight as to who's telling the truth or who's doing what. And our role was to keep the peace and to effect the transfer of the youngster from one parent to the other. And as far as the report requirements, in most of these cases, a report's not really required. The officer on the scene can determine whether or not any other laws are being broken. Is anybody being physical? Are they disturbing the peace? Whatever. We generally keep the peace, effect the transfer, and send people on their way. So if you could address the extra burden it's going to put on law enforcement, keeping in mind that they're there to keep the peace. They don't have the documents from the court in 99% of the cases. They don't know who's telling the truth. And quite frankly, it's not their job to be truth detectors.
Before we listen to the rest, it's not their job to be truth detectors. It is in any other case. If you
Yeah.
show up to an alleged assault, part of your job is to determine who is being more truthful. But in this case, it's not. And he doesn't think that cops should be involved in enforcing this one crime. This one crime. Every other crime, yeah, they should enforce it, but not this one. And I want to add, I reached out, I sent an email to all 5 of the Judiciary Committee members who voted against this. None of them came back to me. And one of my questions was, well, you don't like this, but clearly based on what the task force heard, this is a huge issue. So what is your solution? And that was something I asked the chief of police's office in Meridian, and no one will give me an alternative.
The fact not in evidence is that the police are programmed to receive. Okay, What we just heard is Mr. Foreman saying, they don't have the order in front of them, and we have the.
But look, that's
wait,
easy to.
Mike, let me talk. He doesn't have the order in front of him, and we have the other senators saying that the law is on the books for the worst of the worst cases. Well, the cops already are operating under the idea that arrests will be made under this statute only in the worst cases, only when it's a repeat offender situation or it's a violent taking of children and there's a mass of police trying to get them. It's clear when it's one of these egregious situations. When it's a non-egregious situation, when it's a run-of-the-mill situation by these senators' own definitions, there's not going to be an arrest. The problem is that the police interaction and the fact not in evidence is that police interaction appears to be designed for arrest. Police interaction under this statute is designed for evidence and factual development. It's for evidence determination or factual determination. On this date, we did observe and we did receive a call from X that said that Y had the children and shouldn't have the children. We went to Y. We saw that the children were okay, and we have a report, and here it is. You don't do anything else beyond that. They do the walkaway. The cops love walkaways now. You got a drunk guy who's got armed to the gills. Rather than 10 cops trying to breach the house, they walk away, and the drunk guy sobers up, and nobody gets hurt. Same thing. Don't go into the house. Don't go looking for drugs or alcohol or anything else. You can do this from the curb. You can say, okay, I'm here. Do you have the kids? Show me that the kids. Kids, are you safe? Yes, we're safe. Okay, I see there's nothing visible on you. Okay, I have my report. The problem is that police officers are programmed to receive. And that's the fact, not in evidence. And that's why there's so much hostility. Because the people who want this bill are people that are programmed for the best interest of the children. And it looks
Mhm.
like these two senators and some of the people advocating for the police aren't taking that consideration and giving it the weight that it should have, the best interest of the children and keeping the safety in that way.
All right, let's keep listening.
They're there just to keep the peace. So if you could just address that.
Sure.
Representative Scott.
Thank you, Mr. Chairman and Senator Foreman. I'll share something and then maybe my co-sponsor wants to add. But we say that the officer may document the encounter. We've talked to several law enforcement officers. We're like, are we putting more burden on you? They're like, we get called for these cases regardless. We get called all the time. This is like one of their number one issues that they deal with all the time. We put enough wiggle room in there with the may, I think.
Thank you, Chairman, members of the committee.
And we're going to hear that. That's one of several people who was victimized by custodial interference. We're going to hear from him in a minute. One interesting thing she said is that, number one, obviously she did talk to cops. So maybe they didn't talk to the Meridian PD police chief in trying to craft the bill, but they said that the Sheriff's Association from Idaho supports the bill, that other cops support the bill. I'm going to trust that she's not lying to the committee. So I think she has had input from the cops. But one of the most called in things, rarely enforced. So basically, in the state of Idaho, you have carte blanche to violate a custody order and keep a child and engage in custodial interference because the cops' hands are tied. And when we've untied them with HB 668, it's been voted down. Anything you wanted to add?
I think that Heather Scott made the point pretty well that they're there, and you did too, that they're there anyway. And this is just that we're asking for. And the cops that are on the street that do this and they get these calls, domestic disturbance, they're there to keep the peace. What's the nature of keeping the peace? Make sure that nobody's harmed, make sure that nobody has a weapon, make sure that nobody's intoxicated, make sure the kids are okay. Once those things are there, then the cop really has nothing else to do. These aren't people that are quote unquote breaking the law. This is just something to ensure that we have the facts in place, right? Unless the cops have a custody order and they have a repeat offender or a situation where they know, that the person is breaking the law after a judge's warning, there's not going to be an arrest. This is going to be a separation.
This guy Foreman, there's an easy fix to the one problem that he claims is there. They don't have a custody order. Then put that into the law. Say the parent accusing the other parent of custodial interference shall have a custody order that they will swear is a true and real copy and be subject to appropriate penalties if they try to pass off a fake one. Say in the law that it's required that the cop must be given a copy of I have a custody order. Everyone who has a custody order should either have a paper copy or an electronic copy somewhere that you can get to anywhere, because you never know when you're going to need it. I don't think that's that big a deal and not a difficult fix, nor is it a difficult fix if you're saying, well, they got to make this decision in the field, and put another amendment and say, give them 72 hours to do the appropriate investigation. The ultimate goal is to get it right, whether a parent was engaged in custodial interference. An extra 72 hours is not going to be the end of the world if it's much better to get it right. So put that into the law. The things that they're saying seem like nonsense, and these state senators look like they just don't want custodial interference laws to be enforced.
Yeah, I think you're right. I think that idea of sending getting a copy to the police of the judge's order that's sworn to that's by the complainant might be something that could be tied to triggering the shall portion of the amendment, the things that the police officer shall do. In lieu of that, if they don't have a copy of a custody order, the cops can still do a wellness check. Yeah, anybody can call for a wellness check, and so that would serve the idea to make sure that the children are okay.
Right. You don't need that. You don't need a new law to do a wellness check. But if you're worried about a custody order, then make that a requirement within the law. Now, this is Andrew Kilgore, who's going to tell you a heartbreaking story. And the state Senate Judiciary Committee basically told him, too bad, so sad.
Committee. I am Andrew Kilgore from Canyon County, Nampa, Idaho. I am present here in support of the bill, House Bill 668. I am a parent with court custody order agreements. I'm here today because I've experienced custodial interference and have struggled to get meaningful enforcement of that order. Having been in the family law system for 3 years consecutively for my youngest and 6 years consecutively with my two oldest children, timely action, justice, and affordable are not words that I've experienced with the current family law. When parenting time did not occur and was interfered with, I sought help through law enforcement, through the courts for motions to enforce. Those motions were granted, but never enforced. However, I was able to receive a formal report for custodial interference that was cited by a judge. Even with that document and ruling, neither courts or law enforcement have been able to help. And as a result, I've lost approximately 16 months with my oldest due to custodial interference on record, and close to 12 months with another child that is ongoing. That time cannot be replaced or has ever been offered to be made up. The current system often requires parents to return to court, retain or hire new lawyers, and wait months for a hearing just to enforce an order that already exists. And a parent that follows the custody order gets punished. The system has failed the children, and the fit parents wanted to be in their child's life. Many families cannot afford the family law sessions, especially when laws are not enforced. I believe that House Bill 668 ensures that court orders are meaningful and enforceable. Court orders are only meaningful if they can be enforced. I thank you for your time and consideration of my testimony.
All right. And they heard from a lot of parents. They heard from Robert Garza, who's not even from the state of Idaho. They didn't care about the pain the parents are going through. All they cared about is that, woe is me, cops are going to now have to go into the field. They shall verify the location of the minor child, shall check on the safety and well-being, shall complete a written offense report based on the law enforcement's findings. Woe is me, how terrible. They're going to have to do all of these different things. So terrible. Now, since the legislature agrees wholeheartedly that police should not enforce these orders, I have a solution, and it comes from the state of North Carolina, where I have my custody order. You ready? In North Carolina, can an alleged victim go to a magistrate for certain crimes and get a summons or an arrest warrant? Yes. In North Carolina, an alleged victim can directly approach a local magistrate and initiate criminal charges. They should follow North Carolina's lead. Now, ironically, not for custodial interference, because that crime is a little too large. Custodial interference is investigated by cops. Idaho should write a law, put a magistrate judge on duty 9 to 5, Monday through Friday, except for federal holidays. And if you think you're the victim of custodial interference, you go to the magistrate judge, you present evidence. If the magistrate judge believes there's enough for probable cause, they either issue a summons or an arrest warrant. The difference is an arrest warrant, you're actually arrested. A summons, they say you got to show up on this date, and then you have to show up. And that's the way to resolve it. If you don't think cops in the field are smart enough to do it, then write a law this way. Your thoughts?
That's not a bad solution.
It's actually not that good. I think the problem with that is you're going to have parents going, because if if the aggrieved parent shows up in front of a judge and the non-aggrieved parent isn't there, probable cause is not that hard to reach. It's a it's
Right.
a
You're right.
right. It's a
And
story.
it
And
becomes a
now,
mini silver. It becomes a mini silver bullet. You know,
right,
in every
correct.
divorce case, there's
But
going
you,
to be a magistrate finding. What
but
have
you,
you looked at what North Carolina does? Like how
oh
prevalent
yeah.
this is?
How
What
it's
happens?
prevalent on low level crimes. I know this from firsthand experience. On low level crimes, the alleged victim goes in, tells the magistrate, and if the magistrate thinks there's probable cause, either a summons. If it's low level, it's a summons. If it's high level of the low level crimes, it's almost exclusively misdemeanors that they do this for. Then they issue an arrest warrant, and then the cops have to arrest them. The cops either issue the summons or the arrest warrant, and then there's a date, and then your your criminal case starts, and then the prosecutors are alerted, and they can after the fact drop the charges. I think it's a very haphazard system to do it. But look, if you're not going to have cops do it, then the way to do it is through the magistrate. I don't, I don't know what the solution right now is. That this guy Kilgore is shit out of luck, because they're not going to enforce it. They're not going to do anything, and the other parent's just going to do that with impunity. So yeah, no, it probably would become a silver bullet. Yeah.
You got to put the penalty on the bad parent. Robert Garza talks about this a lot. He's one that pushes a lot for an actual tort, a civil tort about wrongful deprivation of custody. That you can sue the other parent in tort on that. And he's tried to get it in, I think, in Texas and some other places, which that might be part of the solution. A monetary type situation. I think that you have this magistrate thing. I think it's open up to abuse. I think very clearly you could have vexatious litigators. You could have the crazy parent that goes there every day or every week to try to get the guy or that girl arrested. The psychopath. You also
But
have
that's
a situation
also better for cops. That's also better if it's cops, because they would have that information. Whereas if depending on how they do, if it's the same magistrate day after day, then that magistrate might get the hint as well. But
the cops
I
all know when people make the calls, for the wellness checks, for the this, for the that. They know when the address comes up, what's going on a lot of the times, because it's the usual suspect. That's very true. And you got to trust the knowledge and experience of the cops. I like the fact that to give the cops some outs and to give some things there where the full-fledged thing doesn't have to take place, where they can use their discretion. But I like the idea of the statute having a threshold where they shall collect the evidence, the who, what, when, where, why, and how. Maybe they can't make an arrest at that point, but they'll have an actual record. And I like that for family court, litigants, so that they have something to put together here. They have something to bring to the court and say, look, we have this police report, and we'll bring the cop in to testify. If we have to, we will. But we have this report here, and the judge can know what's going on. The judges in the family courts can usually consider hearsay, which that report would be. So it becomes a situation that I think it gives the judges the best opportunity to understand what's going on as well. So, and I don't think the cops can be co-opted the same way the system can be co-opted through silver bullet tactics and through other types of things. So
to sum up, the legislators against this think that if cops are forced to investigate every single allegation of custodial interference, that would be too much, which says a lot. And number two, they don't think cops are equipped to investigate allegations of custodial interference, which is a criminal statute. And that should tell you everything you need to know. I don't know the reason that they're against it, but I don't believe for 1 second that it's because they don't think cops can do this. Anything you wanted to add?
I agree with you there. I think that the situation that they gave, the answers were very, very poor.
Right. All right. We'll be back next time.